Thank you. Good morning, everyone. My name's Rebecca Stadler.
Wait a minute. Good morning, everyone.
Good morning.
Okay, give her a good morning. Good morning. Yay!
Thank you. I think what I'll do is just tell you a little bit about myself and my law firm, and then we can either go into a PowerPoint presentation or have a more informal discussion with questions. I can tell you about my background, and then if your questions match up to my background, I should be able to answer them. But if they don't, well, I might have to say something like, I don't know. So as she mentioned, my business partner and I started up about 5 years ago. Our situation changed. We were both at a big law firm, and then we branched out on our own after a while, doing some marketing and some research. And we're both registered patent attorneys, which means that we've got a science background and a law background. And we actually had to take an additional bar exam over the New York State bar exam. So that's what we did, and that's where we were pigeonholed into at our big law firm. And from there, as a result of kind of going out on our own, we sort of expanded on into trademarks and a little bit of copyright work and contracts and licensing. And so our base of knowledge has broadened quite a bit since we were at the big law firm, just sort of doing the same thing every day. We've acquired quite a bit of knowledge in the trademark world, not so much in the copyright world, and the reason for that is that there's not a lot of actual work in copyright law, because the problem is when you need to enforce a copyright, it's very expensive. So for an individual artist, it gets a little bit tricky in terms of trying to enforce copyright. And with the internet, as you've probably studied over the past couple of weeks, copyright is really easy to steal. So it's a really tough area of law with the internet. It's an example of where the law is just not catching up with the technology. And I don't really know what the solution is for that. Another thing I wanted to mention is that my business partner, John Del Vecchio, and I are both clients of the Small Business Development Center. I give presentations at their monthly Survive and Thrive on business formation and intellectual property issues. So I'm also a little bit well versed in business formation. So if you've got any questions along those lines, I might be able to answer those as well. When I was in law school and studying in my engineering degree, of course, you know, all of us patent types walked around saying, oh, patents are the most important type of intellectual property you can have, it's the strongest, it's the best you can have. It's interesting, as a result of working in the trademark area a little bit more, I'm starting to realize I think trademark law is actually more powerful than patent law. So don't tell the patent attorneys that you heard that, but I'm starting to think that that's true. So with that, I can either start my formal PowerPoint presentation, which is probably going to repeat some of what you've learned, or we can just open it up to questions and I can try to answer them. Trey?
Yes. The one question I would have would be, why do you think that trademark laws are stronger than patent laws?
It kind of forces out your competitors. Have you spoken about trademark law in this class at all? Okay, so that's where I can come in and sort of fill the gap a little bit. What I'm going to do is actually, okay, you have a good understanding of what intellectual property is, right? Okay. I don't have too much in the PowerPoint about trademarks, but what they do is they identify the source of goods and services. For example, your computers are from Dell. So did they go to the Apple store and buy the computers? No, they bought them from Dell, probably online, right? Does anybody have a coffee cup or something, or a water bottle? Okay, who's the water bottle? It looks like Poland Springs. So is that from Dasani? No, we know it's from Poland Springs, right? That's what the trademark does. It's either a logo or a name or a slogan that identifies where the products are from. So if you see packaging that says "Just Do It," do you think that the sneakers inside are Adidas?
No.
They're Nike, right? So that's what that does. And what trademark does is it serves to prevent consumer confusion. So the idea is when the person sees the logo or the name, they need to know what company that came from. So if you walk into a Tim Hortons and you get a really, really strong coffee, wait, this isn't right. Tim Hortons is not as strong as Starbucks. Is this Starbucks coffee? What's going on? I'm confused. And we can't have that. We can't have the consumers be confused. They need to be protected from confusion. So that's what trademarks do. You attach the trademark to a certain category of goods or services. Nike, we think of sneakers and shoes and athletic wear. Starbucks, we think of coffee. Ford, we think of automobiles. So that's where the trademark attaches. And so in the case of patents, if you have an invention, the patent will allow you to prevent others from making your invention, but they can sort of sneak around it, right? They can innovate around the patent, if that makes any sense. So the trademark, the goods might be similar, right? You've got Nike, you've got Adidas, Reeboks, all the goods are similar, but you're preventing them from using your name. So out of those three, I'm not 100% sure if this is right. If you had to own which trademark, which would you want?
Adidas.
Sorry?
Adidas.
You would want Adidas? Would anybody want Nike?
I would.
I think I'd want Nike as well. They've got the stronger mark. So you're not preventing somebody from taking your good or service, but you're preventing them from using your good name. So Apple would be another really, really powerful trademark. And that's what you do. You start to collect goodwill and recognized quality. Sony is another example. You see the Sony mark, you know, okay, this is going to be a good stereo or a good television or whatever you buy. And you're just going to kind of glom onto that product, and maybe you would buy that over JVC as an example. And
Alex.
sorry?
Alex.
Alex?
Yeah. So does that mean technically, like, if you could make like a carbon copy of an iPhone and just put a different name on it, like you could get away with that?
Well, not exactly, because the patent stuff does kick in there. So the combination of trademark and patent is ridiculously powerful. But in the case where you're selling something that the technology is no longer covered by patent, you can probably come in and sell the same thing. For example, Band-Aids or something. There's no more old-fashioned Band-Aids. There's no new technology on it. Anybody's making it. Do I want the Band-Aid version, or do I want the one that reads Wegmans? I don't know about Wegmans quality, but I know Band-Aid, they always stick well. They're waterproof. I'm really happy with them. I'm going to stick with the Band-Aid version. So in the case where the technology is no longer covered by patent, the trademark is really, really powerful there. It's also very powerful when there is patent protection. So the example of the iPhone, you've got the Apple logo there, and a lot of people they'll just jump on any Apple product, and they may skip over the Samsung. And the Samsung's invention is going to be a little bit different to avoid stepping on Apple's patents. Artem?
Yeah.
Artem, okay.
Is it possible to get a patent for like your invention that goes like over standard like 20 years?
Not really. Are you sort of thinking about the pharmaceutical industry? There's some ways you can get around that. So what I can do is back up and talk a little bit about the standards for patents, which you may remember. Okay, the first trick for patent law is that it needs to be useful. That's pretty easy, right? Most things are useful that you invent. A phone is useful, a coffee mug is useful, computer's useful, desk is useful. So that's a pretty easy standard to meet. The next standard is that it has to be novel. That's a lot of times that's pretty easy. All you do is change one little thing. So then it's novel. So it's not, oh wow, I can get a patent real easy. Well, that's not true, because then the next step is that it needs to be non-obvious. And that's where things get a little tricky. So your invention has to be useful, new, and non-obvious. So that's a very subjective standard. We probably don't need to get into it here. But in the pharmaceutical industry, as you can imagine, it's fairly straightforward. Okay, I've got a new medicine for headaches. It's useful. it's new. And the way the chemical elements are arranged, it's completely non-obvious. Nobody would have thought that it would work as a headache medicine, and so you get a patent on it. But, as you may or may not know, in the pharmaceutical world, the pharmaceutical industry has to go through a lot of hurdles with the FDA. So they get their patent, the patent lasts 20 years from the date of filing, and then they have to hang out with the FDA for a really, 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 really long time. So the Congress has come along and they've added on a little bit of extra time for the patent in the pharmaceutical world because of this regulatory FDA issue that comes up in the pharmaceutical industry. But what happens is it still doesn't last very long. The pharmaceutical companies, they spend a ton of money coming up with a lot of medicine. A lot of the medicines don't actually work, or they don't go anywhere, or they're not safe. So they spent money that goes nowhere. So on this one thing that they get, they want that patent to last as long as possible. So what they'll do is they'll come along towards the end of the life of the patent, and they'll try to tweak it in a way that, again, is useful, novel, and non-obvious. So what they might do is they might try to develop some type of extended release or something. I think that's what they did for, what's the allergy medicine? Claritin? I think that's what they did. So you've got the regular Claritin, and then the one that slowly releases out over 12 hours. So it's new, it's useful, and then they're going to have to make arguments to the United States Patent and Trademark Office that the way that they get it to slowly release is non-obvious. So that's the only way that you have to do some type of modification to your invention in order to sort of build on the earlier one in order to get anything past 20 or 25 years. Do you have another question?
Yeah, do you know about the Disney suit against Deadmau5 for the trademark?
I've seen a little bit about this, yeah.
What do you think of that? Like, do you think they have rights to sue?
Disney? Well, this is actually...
Can you speak up a little bit? Can you speak up a little bit? Is it you? Who's talking? Can you just speak up louder? Because I can't hear you.
What do you think about the Disney suing Deadmau5 for confusing the trademark? Deadmau5's trademark with Disney Mouse?
I think, I looked at that a couple weeks ago, so it's kind of fallen out of my mind a little bit in terms of what happened. I think Deadmau5 sounds like he was kind of being dumb about it. There's an interesting, one thing that I've seen is a small intellectual property boutique law firm in Buffalo, is that there's sort of the legal thought process of how you come out with respect to the law, and then the legal reality, which is that Disney has a lot more money than everybody. So in a lot of cases, they're going to end up just staying in court as long as they can, and just sort of forcing the other person to just settle. I don't remember the exact issue there, but wasn't it the case that Disney wanted to use Deadmau5's songs or something? And he started getting real persnickety, and then he sort of created a lot of problems for himself, if I recall.
I remember reading, I think it was Disney, they wanted to sue him because they thought that people would confuse his logo for the Mickey Mouse logo. And then I think that was articles that he just told Disney to bring out the lawyers or something.
Right, that was, yeah. So here's a little bit of life advice. Don't go to Disney and say, bring on the lawyers, because Disney will. I think in the case of Disney, it brings up a very interesting issue in the trademark world, which is called famous marks. You have your regular trademarks, which cover your goods and services, and if somebody comes along and they use the same name as you, but they do something completely different, they can get a trademark on that. So for example, is everybody familiar with Sweetness 7 coffee?
It's a coffee shop, not far from here.
Has anybody
and
heard of
it's small,
Sweetness
it's
7?
independent.
No one's heard of it. Okay.
It's okay, it's still a good example.
Okay. It's a little coffee shop, right? Everybody loves it. They've got great coffee, great food, and it's called Sweetness 7. Now, if somebody on the other side of Buffalo wanted to come along and start making athletic wear called Sweetness 7, they'd probably be allowed to do it. And the reason is because the goods and services are so different. Sweetness 7 has coffee, and these people are making baseball bats. Nobody's going to think to themselves, oh, those baseball bats are from the coffee shop, right? That's what we have to worry about. But in the case of what are called famous marks, Nike, anything from Disney really, Ford, they get an extra level of protection. Ford Motor Company, they really only make cars. They haven't started making sneakers. So you would start to think maybe, oh, I can come along and make Ford sneakers. But you can't because there's legislation that gives a little bit of extra protection to what are called famous marks. And this is an anti-dilution statute. So to prevent anybody from thinking that big Ford Motor Company is now making sneakers, we're just not going to let anybody use this mark for anything except we'll only let Ford Motor Company use it. Nike would be another example. Disney, as you can imagine, their trademark portfolio is huge. One interesting thing, though, that Disney did is that they've got all the money, they've got all the attorneys, but they lost a PR battle a year or two ago because they tried to trademark, and I'm not even going to attempt to say it. Does anybody speak Spanish in here? Anybody? Nobody speaks Spanish?
He does.
Oh, you do? Can you say Dia de Muertos? That one? Can you say it? Yeah, that. So it's like Day of the Dead, right? And they tried to get a trademark on that, and everybody was up in arms about it because they said this is a holiday, you can't get a trademark. And Disney actually, I think they could have gotten the trademark, and I'll tell you why. Disney ended up backing down from it because the entire Hispanic community was up in arms over it. And they said, you can't trademark our holiday, what does this mean? We can't use our own name to describe our holiday. That's not actually what trademark law gives you rights over. But what happened is that the PR fallout was so bad that Disney just backed off from it. So let me give you an almost identical example. There is a trademark for the word Halloween for the Halloween series, the movies. Does this mean nobody can say Halloween? No, because all it means is that the people that own the trademark for Halloween, they're allowed to use the mark Halloween in connection with movies, and nobody else can. That's all it means. So you can still sell Halloween candy, Halloween costumes, have a Halloween party, all of that, and you're not infringing their trademark because you're not offering any goods or services, in the case of a party really, but to the extent that you are offering goods and services, you're not offering a movie. And that's why, in my opinion, Disney probably would have gotten the trademark if they hadn't backed down. So it was very interesting. That was kind of an example of where intellectual property meets pop culture, which is happening more and more these days, I think. So do I have any other questions? Cam?
Yes. In that sense, for your reference to Halloween, now, are you still able to use the word Halloween in a movie title?
That's a really good question. I think the answer has to be yes, because the Halloween movies are horror movies, and as long as it's not a horror movie that's just using, I don't know, a Halloween party, but it's very clearly a horror movie that's trying to piggyback off of Halloween. There's a series of factors that you look at for trademark infringement, and they're called the Polaroid factors. One of the factors is the strength of the mark. Halloween as a movie series is probably pretty well known. You look at the similarity of the marks, Halloween versus Halloween party. Those are pretty close. You've just added one word. The similarity of the goods and services is another factor. And if it's a movie and a movie, they're identical. So we're starting to look at some factors that are weighing in favor of a finding of confusion. Now if it were, I don't know, my sweet 16-year-old's Halloween party, and the type of movie is very different, there's a lot more words, it's clearly not a horror movie, I think that would be okay. So The answer, as in all legal questions, is it depends.
Yeah. All right, now, do you think that's the reason why some of these companies and products have like names that are spelled funny or spelled differently than you would usually use the word?
That might be done because it could be for that reason. It might also be done as a way to be descriptive without the trademark office thinking you're descriptive. When you sell goods and services, you can't get a trademark on something that is purely descriptive. So I can't go out and get a trademark on apples in order to sell apples, because then what happens? Nobody else can sell apples. But if you're Steve Jobs and you want to come along and call your company Apple and sell computers, that's fine. So they may be doing an odd spelling in order to sort of be descriptive without actually being descriptive,
Okay.
if that makes any sense. And was there a question over here, Trey?
Do you feel like the types of intellectual property are sort of monopolizing on ideas instead of trying to create innovative and new technology or experiences or art in a sort of way?
I'm a patent attorney, so the answer to, in my opinion, is no. But I know that in the software field, a lot of people think that way. I'm of the view that patent law in particular really pushes forward innovation. And the reason I say that is because in around the 1300s or 1400s in England, what happened is they had a steam engine, and the technology just languished. For hundreds of years, it never got any better, never got any better. It works good enough, let's not fix it. If it's not broken, let's not fix it. Well, what happened is that the Crown in England started issuing patents. So you've got a little improvement on a steam engine, and that means that that guy down the street can't use it. So what does he have to do, or she? He has to innovate around it. And in theory, hopefully, right, the technology moves to here, you innovate around, it moves up here, innovate around, it moves up here, and then it keeps on moving forward. So when the patent system was introduced in England, we actually saw the technology of steamships move a lot quicker. So for most technologies, I think that the patent system actually pushes innovation forward. I believe you've been speaking quite a bit about software, and in the software world, that may be a little bit different. Maybe open source does make a little bit more sense than patent protection for software. I'm not really sure, because the patent protection for software, it basically changes on an almost daily basis in terms of whether software is eligible for patent protection. So I don't know that the evidence is really there for me to make a conclusive guess on that. I'll go to, is it Sarah?
So if I'm working for one company and I write software for them from scratch, and I move to another company and they want a similar one, would I be allowed to write a similar software from scratch?
This is a really great question. That's actually going to depend on what your employment contract says. I'm glad that you asked that, because I probably would have forgotten to talk about it. But what's happening now in a lot of employment agreements is that everything that you make, even at home, at work, everything is assigned over to the company that you work for. The companies are starting to get really, really serious about their intellectual property. So at an engineering company, for example, it goes without saying that anything that you make on the job is going to be the property of your employer or your boss. And even though it goes without saying, that's always put into a contract. But they've actually started going a step further, like I said, and if you're tinkering at home on your lawnmower and you make an improvement, they actually might have the right to that, or the right to first refusal, which is you tell them, hey, I was tinkering on my lawnmower, and they say, okay, well, we don't worry about lawnmowers, so we're not going to take that. You can go ahead and get a patent on that. In the case of software that you're producing from scratch, it's really going to depend on what your employment contract says. And often with the big technology companies, they have non-compete agreements, which might say that you're not able to work for a similar company within 20-mile radius of this company for the next 2 years or something. So it's hard to answer that question for sure. But if you come up with it from scratch and there's nothing in your employment contract that says anything, you should be okay, unless if it's patented, there might be a different analysis there to see if they're just equivalent, then there may be some type of patent infringement. So that's actually a really hard question to answer. But it was a great question. Artem?
Is there anything you can't trademark?
That you can't trademark? Oh, that's a very good question. Are you thinking of the Washington Redskins?
No, just like
Yeah, you can't trademark that anything that's any words that are offensive. And what happened recently, does anybody watch football? Does anybody pay attention to the?
Watch football.
Okay, everybody watches football.
Yes.
You've heard of football? Okay. What happened, it was maybe about 6 months ago, is that the trademark office actually canceled the name Redskins for the Washington Redskins football team. Now, it's going to go to appeal. It probably will be put back in place on appeal. It's actually been canceled before. And the reason for this is because some people consider it offensive. So you're not allowed to, you can't trademark something along the lines of like men suck or women suck. It's offensive to a lot of people. So the government's not going to get behind something that's offensive. And so that actually can bring me to a different point completely, which is that all intellectual property is granted by the federal government. So when the government grants you this piece of property, if they grant something that says men suck, well then it almost looks as though the United States federal government is endorsing a policy of men suck, right? And that we're not going to be happy with that. We don't want the government getting involved with things that is offensive to people, and so that's part of the reason behind that. So that's one of the limitations on on trademark rights that I can think of. Did you have something else in mind? No. Yeah, not really. I mean, it can't be descriptive, like I said. You can trademark a name, you can trademark a logo, a slogan. You can actually trademark a little jingle, like the NBC jingle. You can trademark color, Tiffany Robin Egg Blue. Is everybody familiar with the store Tiffany? And that sort of Robin Egg Blue color. So they're allowed to use that color in connection with their store, and other stores can't use that exact color. And you can actually trademark smells as well, but I can't think of an example.
It's Connor.
What is it?
Connor.
Connor.
I know there's a lot of controversy on the term Redskins.
Uh-huh.
I was just wondering who's given the authority to decide whether it's considered offensive or not, because I know there's a lot of debate on both sides.
Yeah. In this case, it's the trademark office that made the decision to cancel it. I believe it'll go up to the appeal level at the trademark office, and they'll just have to look at the evidence of whether what set of people find it offensive and make a determination. Like I said, I believe that mark has been canceled before, and then the appellate level brought it back, and now we're going through it again, and we'll have to see what the appellate level does. When they registered the mark, it wasn't really considered offensive. I think it was maybe the 1920s or 1930s, and as standards have evolved, some people are starting to find it offensive. So it's the trademark office, to answer your question, and the appellate level at the trademark office. They might be able to bring it to the federal courts as well if they keep on going in terms of the appeal, but I'm not 100% sure on that one.
Okay.
Tim.
Do you think if their logo was different, this controversy wouldn't be happening? 'Cause the
Possibly. Yeah. Yeah. Because, yeah. then maybe if the logo was completely different, you wouldn't exactly know what they're trying to say with Redskins, but because of the logo, yeah, you sort of see what they're trying to get at.
Right, and also, now, a lot of people, well, I have family that are Native American,
Uh-huh.
and they get mad when they're referred to as Indians. Do you think the Cleveland Indians are going to have to do the same thing in baseball?
Is their logo similar?
I believe so.
That's possible. I think most people can see the argument as to why Redskins is offensive, but most people at this point probably don't see why Indian is offensive. That may change as opinions evolve on that as well. But I think there's sort of a little bit more of a negative connotation that goes along with Redskins.
Right.
Indians are probably offended because it's just completely inaccurate.
Right.
But it's not meant to be offensive, whereas Redskins is a little bit more intentionally offensive.
Okay.
How's that for a non-answer?
Yeah.
Only an attorney could give a non-answer like that, right? So you have to go to law school so you can not answer questions too, right? Artem, do you have another question? Does anybody else have a question? Wesley?
Do you actually feel that the word Redskins is offensive?
What did you say?
I said, do you actually feel that the word Redskins is offensive?
So if I were the person making the decision at the trademark office and it was just me,
Yeah.
I don't know. I'm kind of on the fence about it. I do think, on the one hand, they've been called that for a very long time without too much incident, but with evolving standards that we have, I'm kind of, it sort of does seem like it's offensive. I'd probably have to look into it a little bit more. I'm kind of on the fence on that one. If I were making the decision, I'd have to think about it long and hard. How's that for another non-answer? Okay, now I'll turn it on the class. If you had to make the decision, would you cancel the trademark for Redskins? Or, okay, would you let it stand? Okay, so you would let it stand. Okay. Is there another way that we can tell the Redskins we're not happy with them without canceling their trademark?
Ask them to change it politely.
Sorry?
Ask them to change it politely.
I was thinking of something a little bit more forceful than that. Sorry? Fishing? A petition. I was actually thinking something of what is like the most important thing in America? Money, right? So stick it to them in their pocketbook. Don't buy any Redskins merchandise, don't buy any tickets, don't go to the game. If they're playing your hometown team, don't watch it. That's never going to happen because it's football and everybody's addicted to football, but that's one way that if you're not happy with a company, you can sort of send them a message. Or send them a polite tweet. Please change your name. Thanks and stuff, right? Or a petition would be good. Any other questions? Artem?
Hopefully this is the last question. Why do they, overall in trademarks, why do they favor big companies so much? Because, for example, if Disney really wanted to, they could just wait everybody out until the other person ran out of money. Wouldn't it be fair for, there to be a law or something passed where, a decision has to be made within a certain amount of time so it's fair for both parties?
Yeah, you're asking a very important question that cuts across all levels of the law, not just intellectual property. Unfortunately, in the legal world, what happens is that money can buy you more time in court, it can buy you more attorney power, and for example, if you're some person that was accused of murder and you don't have any money, you get a public defender. The public defender is overworked, doesn't have enough time or resources to devote to your case, and if you're not very well off and you're accused of murder, you can get a really high-powered attorney that may find some argument that the public defender isn't able to find, and so you have a situation in the criminal justice system where justice doesn't really happen because money buys justice, and if you're very poor, you don't get it. And then the same thing happens in the intellectual property lawsuit world, which is that somebody like Disney can sort of hang out in court until the other person runs out of money. You see that in the patent world also, where Monsanto sues small farmers for allegedly stealing their seeds. And I don't know if you've read this in the newspaper, but Monsanto can hang out in court for years and years and years, and the local farmer can't, so has to settle and sign some agreement. And the only way around that is a huge overhaul of the legal system, which, you know, may or may not happen anytime soon. And that is totally far afield of the original topic. But I also teach forensic science, so in my professional world, I combine science and law in the patent area, and then in forensic science, I combine science and law in a little bit of a different application. So that's why I talk about criminal justice system a little bit as well. But that's a great question. It's something to think about. Maybe policy change would need to happen. In my presentation that I didn't get through, the Copyright Office actually proposed something similar, a small claims copyright court, and the reason for that would be that the independent artist could go to the small claims court and sue somebody for copyright infringement rather than go to the federal court and have to go through all of that time, money, and expense and energy. So the Congress is thinking about it a little bit, especially in the copyright world, so maybe it'll start to go into the trademark and patent world as well. But that's a really big problem that there's no great solution to at this point. Another reason they favor big companies in some cases is, like I mentioned, the anti-dilution statute, which is that if you're a very, very famous mark, if you have a very, very famous mark, you get a little bit of extra protection than the average trademark does. So you're right, there is even some congressional favoritism towards the big companies. They've got better lobbyists, perhaps.
Yes, I'm Ramona. I have a question, and I'm not sure if this question is appropriate or pertains, but I was under the impression, so there was Prince, the artist, and I was under the impression that he switched his name to the symbol because of copyright or trademark infringement from a record company. They wanted to use his name without his authority, so he changed to the symbol. Do you know anything about that?
Honestly, no, I hadn't heard that it was
Okay.
a trademark infringement issue.
Okay, just in case you knew. And I wanted
sorry.
to ask that question for years.
I should look it up.
Literally years.
I'll look it up.
We have a couple minutes left if there's any last questions. Okay, Trey?
Do you feel like copyrights exist for too long?
You mean in the sense that the internet is so quick and things disappear quickly?
No.
Or just in general?
As in the sense of once somebody or a company owns the copyright, like after they die 70 years, continue, they still have access to the royalties. Do you think that's fair?
Never really thought about it. I guess so. So the copyrights of Michael Jackson, for example, they'll continue on for 70 years from when he died. Yeah, they go to his estate. Yeah, I think so. 70 does sound a little bit long. But then after that, it falls into the public domain and nobody can really make money off of it anymore. So, yeah, maybe it's a little long. Did you have a question, Sarah? I'll get to it.
If I write a program, when does it fall under like intellectual property versus what anyone can do? Like I'm in a programming class now and we have to do different programs. So is that what anyone can do or is that not
I
intellectual
think it
property?
depends on what's open source and what isn't open source, and it needs to rise to, in the copyright world, it needs to rise to a original artistic expression, and it's hard to say what that would be without really having a solid example. And in the patent world, it's gotten a lot harder to patent software, so software doesn't have particularly strong intellectual property protection. And that actually probably is the reason that copyrights do last so long. The protection isn't really that, it's not really that powerful, and so to balance that out with patents and trademarks, they give you a longer time. So if you write a poem and you've got a copyright on it for a very, very long time, but nobody's interested in it because it's not very good, well, you've got this really weak protection on something, but it lasts a long time. Then to contrast, there are some more powerful copyrights. Star Wars, for example, that's a very powerful copyright because you can't even create derivative works of Star Wars because that copyright is owned by, I believe that is Disney now, right? So that's an example of a very powerful one. And then because there is so much money involved, that the length of that copyright does seem a little bit long. But yeah. Do you have a question?
Yeah. Do you feel that the law imposed on the copyright, on the trademark, and the intellectual property, do you feel that those laws are fair to everyone?
Fair? Yeah, I think so. Starting from scratch, it gives everybody the opportunity to go out and get their own copyright registration, their own trademark, their own patent. The fairness issue starts showing up in the enforcement of your intellectual property. It gets a little bit trickier there. I've got a client that came to me over the weekend asking a question about their trademark, and the person using a similar trademark is Twitter. So now, do we go to battle with Twitter, or what do? We need to ensure that our trademark is still active. But who wants to go to battle with Twitter? So I guess maybe getting the intellectual property is fair, but then enforcing it is a little bit trickier depending on who has more financial.
What is
Matt, I'm gonna have to stop you, I'm so sorry, maybe you could talk with Rebecca after
Yeah, I can stick
class.
around.
But we are, but it's time to go, and if we could just stop for a second and give a little clap for Rebecca.